Case of the People versus Marquesi Hankey.
Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, exception.
All right, it's your motion.
Heritage before. So at the very least, the restriction on his phone privileges to contact them.
All right, well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our?
My understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free.
Some defendants make mistakes. Others make the mistake of believing court orders are optional. This defendant had already had his bond revoked, cut off his ankle monitor, and still came into court expecting another chance. That alone is a bold move. Galip hai.
Your bond gets revoked, you get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on our motion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then
the jail calls are what really sink him. He's not whispering or pretending to be confused. He openly says there is nothing the court can do to stop him. That kind of arrogance almost never ends well. When someone starts believing the rules don't apply to them, the consequences usually get much worse.
I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and particularly if you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kid say, mess around and find out. I guess that's not the quote, but it's close, but I did pretty good. I said it.
When the judge says, "You are not that big, not that bad," you can hear the patience disappear. And then comes the line nobody expected to hear in a courtroom. Mess around and find out. It's blunt, but it captures exactly what this defendant was doing. Testing limits, pushing boundaries, assuming there would be no consequences.
Okay, right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I don't think I'm being bad at all. It's very about my child. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. But again, please show mercy. Please. That's all that matters.
I have no problem showing mercy to those that deserve it and have earned it. You have not.
The apology comes too late. At this point, the judge has already seen the actions, and actions speak louder than anything said at a podium. Mercy is possible in court, but it has to be earned.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here with and I'm here. James Dennis Whitney.
This is people's emergency motion to modify violence in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client
Call her to show up to do what?
today to say, I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong.
What makes this hearing even more remarkable is what happens next. The defense attorney suggests the court treats prosecutors differently. That accusation clearly strikes a nerve. But instead of reacting emotionally, the judge does something impressive. He pauses the hearing until the next day, not to punish the defendant, not to prove a point, but to make sure his decision is based on reason rather than anger. That is exactly what judicial professionalism looks like.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in Newton on behalf of Mr. Woodley, who's standing to my right. Will you state your name before, please? James Dennis Whitney.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court.
Why?
No, my turn. The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing. Without notice to any side, I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective, I heard that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it, because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all.
This case is a reminder that confidence and defiance are not the same thing. The defendant thought the court was powerless. The judge showed him otherwise. And when someone ignores every warning, breaks every condition, and still believes nothing will happen, reality tends to arrive all at once. In this courtroom, it arrived with a few unforgettable words. You are not that big, not that bad.